Welcome to the ProfitLed podcast, where we discover proven growth strategies for bootstrapped entrepreneurs from the people who have done it before to help you accelerate your business. The ProfitLed podcast is brought to you by eWebinar, the leading automated webinar platform, which could save you from doing the same webinar over and over again. From sales demos to onboarding to training, eWebinar turns any video into an interactive webinar that you can set on a recurring schedule or make available on demand, which means you can do hundreds of webinars without ever needing to actually be there to host them live. This podcast is a forum for the unsung heroes of SaaS, the founders and others behind bootstrapped startups who are creative and resourceful enough to forge a pathway to success. Here is where they get to share everything they learned along the way, so you can benefit from their experience and find success in your own ventures too.
Welcome to ProfitLed, the podcast for bootstrap entrepreneurs looking to make it happen. My name is Melissa Kwan. I'm the co-founder and CEO of eWebinar and your host. My guests today are not the typical founders that I've had on this podcast before. They're people who help founders every day to protect their businesses as they grow. So if you've heard of patents but know very little about them, then this podcast is for you. Today, we're going to dive into the world of patents, what they are, how they help or hurt your business, whether it's applicable for your business, and the process of applying an approval. I hope that by the end of this conversation, you'll be able to figure out whether it makes sense for you to pursue them and how you can get started. If you've listened to previous episodes before, you'll know that I wanted this podcast to sound like I'm having a conversation with friends at a bar. While it's completely unrealistic for me to invite my guests and meet me at a bar to record this podcast, I thought at the very least we could have a drink virtually here. So here we are today with my two very special guests, Alan Macek and Geoff Mowatt from the law firm DLA Piper. Hey guys, how's it going?
Great, thanks for having us.
Pretty good, thanks.
So thanks so much for coming on the podcast. Which drinks did you guys choose to bring for our chat today?
I have a Golden Axe Blonde Ale from Sawdust City, which is a local brewery here.
Yeah, and I just have a Sapporo beer.
Nice. I like Sapporo. So I've got this bubbly sparkling water, blackberry flavor, because I happen to be in Canada today, and I think this is a Canadian version of LaCroix. So, all right. Why did you guys bring your drinks?
I actually just got this last week when we were on vacation, so it's sitting there at the front of the fridge.
Yeah, and this one's just a beer I drink quite a lot, so like when I drink, but not a lot.
All right, well, let's crack this open. It's time for some ASMR magic. Just do it, maybe do it next to your mic. I also have a glass to pour this in. You're welcome to join us at home, by the way, if you also have a drink close by. All right, cheers, guys.
Cheers.
So, guys, just to give our audience some context, our conversation started because I reached out to our lawyer, Michael Reed, also from DLA Piper, asking whether we should be pursuing patents at eWebinar. And before he got too deep into answering me, a light bulb went off. I thought, I bet there are a lot of founders out there in my position thinking the exact same thing. We've all heard the word patents, but know so little about them and how they actually impact our business. And that's why I asked Mike to put me in touch with his colleagues who specialize in patents so I can have a kind of first discovery call publicly on this podcast for all founders out there to listen in on. And that's why he put me in touch with you guys. So with that, before we dive in, Alan and Geoff, would you like to give us a bit of background about yourself and what you do?
So I'm a partner at the DLA Piper's Toronto office, and my practice focuses on patents exclusively. Part of my practice is working with innovators, founders of companies, and others working on developing new ideas to get them patents, drafting and filing patents, and working on their patent filing strategies. The other part of my practice, which these days probably takes up most of my time, is doing patent litigation. So disputes over patents, who owns them, someone infringing those patents, the validity of those patents. And my technical background is in the high-tech computer science space. And so most of my work is in that sector relating to patents and patent applications, high-tech networking, cloud computing, AI, those sorts of technologies.
Great, and I am Geoff Mowatt. I'm with DLA Piper as well, and I've worked with Alan both of our whole careers, and I do intellectual property law generally, but the focus is primarily patents and patent litigation. As part of that, I work on patent strategy and helping both startups and larger companies with their patenting strategy, both domestically and around the world. We also do other areas of IP like trademarks and copyright and things of that nature.
Mm-hmm. Let's start with the most basic question. What's a patent?
Sure. So I can start with that one. A patent is a grant of an exclusive right by a national government. And what that gives the owner of that patent is the exclusive right to practice what's claimed within that patent for a period of time. And patents have a lifetime of 20 years from when they've been filed. And so during that time, after the patent has been granted, you're the only one who can use that innovative idea that's claimed in that patent in that country, say Canada, if you have a Canadian patent. So at its core, that's what it is. You can then do all sorts of things with those rights. So we'll get into that a bit later, I think. But you can license others to use that idea. They often will pay you a royalty or some other compensation for being able to share in that exclusivity. And then you can enforce it if someone else is infringing that patent by doing what's claimed in that patent within the country. While you have that patent, you can go to court and get the court to stop them or give you compensation for that infringement.
And is that always 20 years?
There are some exceptions to that, but in most of the major jurisdictions for patents, it's 20 years from that filing date.
And how is a patent different than a trademark?
To get a patent or to develop patent rights, you have to file a patent application and have the patent office actually grant you those rights. The trademark rights are developed through use in the marketplace. And so if you have a brand, like a name of your company or the name of a product or whatever, the rights afforded to a trademark owner are developed through use of that trademark in the marketplace. And when consumers start to recognize that brand or the company as the source of that particular brand, and you can apply for trademarks and get registered trademarks as well. But you can think of trademark rights as garnered through use of the mark. Patents, on the other hand, is something you may have an invention, and if you never file for a patent, you will never have protection for that particular innovation. And so you have to apply for it and the Canadian Patent Office has to grant you that patent as a statutory grant.
And what's a provisional patent? Because that's a word that gets floated around quite a bit in the startup world.
Sure, I can address that. Provisional patent application is a uniquely United States creation by the United States Patent Office, and it allows you to file a patent application, but it can be quite informal for the purposes of a provisional patent application, and it gives you effectively a year to formalize your patent application. So you file your provisional patent application. The filing fee is quite low. Basically, anything's accepted from a scan of a napkin to a PowerPoint presentation to something that looks much more like a patent, and then you file it. No one actually at the patent office actually looks at it, but within a year you have to file a formal patent application, and that formal patent application is given sort of the priority of when you file that provisional patent application. So it can be quite effective as part of a patent filing strategy, because you can file a provisional patent application at relatively low cost while you're still perhaps working on formalizing your idea, still working on that. Maybe you don't have all your funding in place yet for doing a larger patent filing strategy. And then within a year, you have some of those building blocks in place, and you can file a more formal patent application and preserve your priority rights.
But is that provisional patent public? Like once you put that in, like submit that, everyone can see that?
Actually not. The provisional patent application is never published, and most patent applications are not published for 18 months from the first priority date. So that provisional application, if you file it and don't do anything, no one's ever going to see it. Even if you file a non-provisional or more formal patent application, no one's going to see that one for 18 months, a year and a half as well. So this doesn't immediately become public.
Yeah, and just to give you an idea about the value of provisional filings and the flexibility, we've had clients where they reach out while they're like flying to a destination and they have a PowerPoint presentation, and so we just file that PowerPoint presentation the day before the presentation actually occurs to make sure that whatever's included in there is actually protected. I also had a case a number of years ago where it was a wonderfully innovative patent and was kind of fundamental to the industry. But the inventor let us know that he actually had written it on a napkin in the car on the way to the airport, and then took pictures of it and sent them to his patent agent. And so that formed the basis of the actual provisional filing. So they are quite flexible, but can be very valuable to make sure you capture innovation at the right time before there's a disclosure. And
is the value of that the date that application was made?
Well, yeah. So the key with patents is in most jurisdictions, it's basically a race to the patent office. And so if you disclose your invention before filing, there are certain jurisdictions where you can actually rule yourself out of getting patent rights. It's called absolute novelty in some European countries and other places. Whereas in Canada and the US, there is a grace period. And so where an inventor discloses the subject matter of the patent, they are in Canada, for example, they're given a 1-year grace period. So if I'm the inventor and I disclose my patent or the subject matter of my patent, I have 1 year within which to file for patent protection, and I can still get that in Canada, and my disclosure won't ruin that and render my invention anticipated. But if I disclose it and I haven't filed, it would ruin it in other jurisdictions, some other jurisdictions.
Just to pick up on that point, the content of that provisional filing, it can also be quite important. If you put down just the idea that came to you on that napkin, so to speak, that can be quite helpful, but it can also not be enough to provide the priority basis for a more formal application. And so I often recommend to clients to look carefully at what you put into the provisional application. Think about potential other variants that come to mind. Where's this idea going to be in 6 months or a year from now? Can we start putting down some of those ideas now into that provisional application rather than just filing the first thing that comes to mind? Because anything that's not in that provisional application, which is in a subsequent filed patent application, can't get the benefit of that provisional. If it's not there, you don't get the benefit of that priority filing.
And you had mentioned it doesn't become public for 18 months. So why 18 months? Like what happens in the 19th month?
The 19th month, your patent application, if it's a regular filed patent application, is now available on the patent office websites effectively. They call it being published, and some patent offices have journals of the newly published patent applications, but effectively what it means is someone can find it when they do a search through the patent office website.
And what are some common misconceptions about patents?
Right. So I suppose some common misperceptions might be that to be valuable, you need a lot of patents, or maybe patents are far too expensive for a startup to afford, or that the patent game is for the big multinationals and not for the small players, or you need to be a patent troll to actually make money from patents. Those are probably some misconceptions. Or another one may be that patents have no value because you can design around them easily by just making a small change. And with the last one, it really depends on the industry, it depends on the market, and it depends on the technology at issue. Often I've worked with some inventors where they look forward at where the industry is going. And if you can get patent protection on some of the fundamental kind of, you could call them gateways to the future in that particular industry, and a properly crafted patent, and that really hones in on the key innovation that pretty much every other competitor is going to need to use to move forward in that industry, you can create a patent that's really hard to develop around, and then that becomes a very valuable patent. So there are certainly some patents that are easy to design around, but those may be in spaces where there's a lot of other patents, and the patent office has decided that you are only entitled to an incremental, a very small innovation, but you nonetheless get a patent for it. And so, yeah, maybe a competitor can design around it, but it really is industry specific and technology specific. And with respect to the dichotomy between is it only for big companies or can little players benefit from patents as well? I would certainly say for startups, obtaining a patent or obtaining patent protection in your key jurisdictions can create enormous value for your company. Often, in particular in the US, I understand there are venture capitalist companies and investors that the first question they ask is, do you have patent protection on this? And so even for the startups, it can be valuable as an asset, and you can decide whether or not you want to assert it. Like once you get the patent, if you want to assert it or not, and we can talk about that later, but you can deal with that later. But at the most basic level, obtaining a patent is a wonderful asset for your company for a variety of reasons.
Would you say it's not true that startups can't afford it? Like, what would you say is like a range of pricing or budget that a startup should be looking at in order to pursue this?
I think the answer, it depends. A big factor of that is how many jurisdictions are you looking for protection? As we talked off at the top, patents are national instruments. And so if you want a patent in Canada, that's one thing. If you want a patent in Canada, United States, that's going to be more expensive. You want a patent in China and Europe as well, then the price goes up. But we're sort of looking at in the range of sort of $20,000 to draft and file a patent application, and the cost will unfortunately go up from there depending on how many more countries you want. But there's certain strategies to defer that cost, so it's not we need that money today to start that process. But the drafting and filing is an upfront cost, but it's sort of the filing and prosecution process of working with the different patent offices is sort of typically a 2 to 5 year process, and so many of those costs are spread out over a longer period of time. But I'd just like to pick up on one point that your earlier question about misconceptions, and I think a big one is patents aren't for necessarily Nobel Prize winning ideas. They are granted for much more incremental ideas along the way. Just because you haven't won the top industry award in your area for your innovation doesn't mean that you don't get a patent. Patents are granted for ideas that are more than something that's obvious. And so if there's something, sort of spark that took you outside the mainstream, then, there's a potential something there that's patentable. And so I think that many, especially I think sort of the people on the ground, the scientists, engineers who are working on this, figure, well, anyone could have figured out this solution, but in many cases, those ideas they come up with are something that is potentially patentable.
But would you say that you submit the application and the chances of that is getting approved is not guaranteed, right? So I'm budgeting 20 plus thousand, 2 to 5 years, even if the cost is spread over time. Like, are you guys only filing it when you know the chances are high, like you've already worked with the client through this process? What would you say like the chances of getting that approved is if you're ready to invest this time and resource?
I think it really depends on the client and the innovation, and there's a couple of things you can do to increase your odds of getting that patent. Many clients know their industry and know when they've come across a really good idea that is more than just an obvious improvement on what's been done before. Often we recommend to clients to do searches to say, okay, what is known in this industry as of today? And therefore we can do an analysis to say, okay, the idea you came up with is something that's more than just a small tweak to something, to existing technology, and there increases the chances that we can identify what the real innovation is in this idea to persuade the patent office that this should be granted. I think overall the grant rate is around 50%. So I don't know if that's considered good odds or bad odds, but that's all in from people filing patent applications, which they probably shouldn't, to ones that are sort of a shoe-in because they just won the Nobel Prize for that sort of ideas. But it's definitely not guaranteed, and that is part of the thought process of should you file a patent application, which is, do you want to put your crown jewels of your business idea into a patent application? It gets published after 18 months, and then your patent gets denied, and your patent application is sitting out there that anyone can go and look at and read, and you don't have a patent on it. So, that's definitely something to consider, and it's a trade-off for filing patent applications.
But as this process is happening, are you able to already build this thing and make it public, or you have to wait till that application is approved before you can actually start using that?
Other than what Geoff talked about earlier about filing a patent application before you make it public, those are separate ideas. Once you have the patent application filed, whether it's provisional or non-provisional, there's no reason why you can't be out there commercializing and selling your idea as aggressively as you can. And the patent application process is going to take its time, but hopefully by the time you're getting further along in that patent process, your idea is taken off. And often that feeds back into the patent filing strategy, which is you don't necessarily know on day one which of your ideas you're working on is going to really take off. And so as you see your big hit, making huge markets are opening up for you, that can feed back into your patent filing strategy and say, okay, we're going to expand the list of countries that we're going to file in because we now have the budget, we now have partners in other jurisdictions that are looking at us for patent protection. Licensing opportunities are opening up because of the success of this product. And so there's certain things you can do in your patent filing strategy to keep those options open for as long as you can to take advantage of that success on the business side. But
you have to file it before you make it commercialized, right? Like you can't just put it out there and then file the patent.
Well, except for the 1 year grace period that Geoff mentioned in Canada, United States, you have a 1-year grace period from when you disclosed it publicly to when you file. But for many jurisdictions, including Asia and Europe, you have to file your patent application before you make that public disclosure. And that often predates the commercialization. You've talked about it at a trade show, you've put it up on a YouTube video, those sorts of things can also be public disclosure. So you want to think about filing at least your provisional patent application perhaps before you do a Kickstarter campaign or announce it on Twitter or those sorts of things.
Yeah, that's right. Well, and so just to touch on that, what we often work with our clients in around that time, right? When they have this innovation and we're working on filing or preparing or filing patents, but they need to talk to people to help them develop, make molds or do whatever for their product. And so at that delicate stage, you don't want to sell it without filing a provisional. You don't want to do a presentation somewhere without filing a provisional. And if you are going to start working with partners, you want to make sure you have comprehensive non-disclosure agreements in place and things of that nature. And if you have a good NDA in place and there's an expectation of confidentiality, then that won't count as a public disclosure. And so that's actually an area where we counsel our clients quite frequently on, because that's obviously, it's at that delicate stage. So.
But say you submit an application for Canada and the US, can somebody in Europe say, oh, you didn't file in Europe, so I'm going to file the same patent in Europe and beat you to that? Like, does that also happen? Hey, I like to take a second here to talk about my own company, eWebinar, and our mission to rescue people from what I call webinar hell, to give them back their time and save them literally hundreds of hours every month through webinar automation. If your sales team is tired of doing the same demo over and over for unqualified leads or worse, prospects who don't even show up, an on-demand demo powered by eWebinar can help them get their time back so they can close more deals. If you're doing customer onboarding and training on repeat, eWebinar can help you automate those so you never have to do them live again. Customer success teams are using eWebinar to run hundreds of sessions every single month without a live host. Why don't you give our product a try and see for yourself? Visit ewebinar.com to join our own on-demand demo or to sign up for a free trial. All right, now that I've gotten that on my system, let's get back to the episode.
It's not that straightforward in the sense that if you filed in Canada and the US and the deadline for you to file in Europe, for example, has passed, and that's kind of it's a bit complicated, but if you are out of luck and you can no longer seek a patent in Europe, for example, for your innovation that you filed in Canada and the US, and somebody else does file a patent application on that same technology, then it becomes a question of whether your filing was public or not. And you could have a scenario where they get patent protection in a different jurisdiction because nothing was public, and you have patent protection in Canada. But as soon as you file your patent and it is published, like Alan talked about earlier, then your published application will prevent others from seeking patent protection in other jurisdictions because it's already in the public domain.
And how can a business determine if they have something that's patentable? Like, are there certain businesses that are more fitting than others?
It's a hard question to answer in the abstract, and a fair bit of analysis goes into that of what is the state of the art of the industry? What are your competitors doing, and what are you doing that's different than what your competitors are doing? And then is that difference an obvious difference or is it an inventive difference? And there's a bit of gray there in terms of trying to draw that line. But that's sort of the basic analysis that you're going to be doing is what is the difference between what you're doing and what are your competitors, what's out there in the industry. And sometimes you know what's going on in the industry because you're really connected, you know what who all your competitors are, but often you don't. You know what people are working on in your space in Europe. If you're working in Canada, do you know what people are working on in China right now in that space? And so that's sort of part of that analysis. How far do you want to search to see what others are doing in order to assess what you're doing is an invention or simply change or improvement that may not be granted by the patent office. And so that's sort of we do patentability searches. We do some of that analysis to go through those differences to try to say, okay, this is something that potentially is worthy of filing a patent application for. A big part of that is even the step before that, which is your engineers, your R&D team are off doing clever work, and they're busy trying to roll out product, they're trying to meet deadlines, they're trying to do it on a budget. And when in that process do you go to them and say, what clever ideas have you come up this week? And should we talk about whether any of those ideas are something that we should consider getting patent protection on. And that is sort of hard often to implement in a dynamic, fast-moving technology and a company that is busy trying to focus on getting their product launched and sort of stepping in and saying, let's pause for a moment before we put that on our social media. Let's talk about whether we want to get a patent protection filed on that before we do that.
And what are the different ways that patents can help a business?
Patents can be quite valuable for, obviously, whether it's a large company or a small company. And the ways it can help your business is at the outset, if you get a patent, for example, in the US or in Canada or wherever, and you're seeking investment, it shows that the heart of your business may be quite innovative and you might be able to do something that others can't do. And investors may see that you have the ability to exclude others. And so it's an indicator of innovation, which is nice. It's a potential source of licensing revenue because you can license it to others if you want. It is the right to exclude others. And so if what we talked about earlier, if there are certain narrowing areas in the technology and you get a patent on that narrow point, you can really thwart your competitors and put yourself ahead of them. And if you're always ahead of them, then you're going to be more, theoretically more successful in the marketplace. And so it can be a competitive tool in that sense. You can also use it as a sword. You can assert it against others and get damages or assert it and get a license that way. And so it can be used in a variety of different ways, some more aggressive than others. But at the most basic level, it's an asset that your company then has. And when you're looking at evaluating the company or seeking investment, it's value for sure.
Are there also ways it can hurt a business, though?
Well, I think there's sort of two aspects to that. One is it's a cost. And so if money is tight and you can spend more money on marketing or R&D or something like that, and as we talked earlier, the patents are expensive and they don't get granted, that's a distraction both in terms of money lost without an asset at the end of it, and it's a distraction for the team, the engineers and the team that's working on supporting those patent filings. I think there's another risk too, which is you put your clever idea into a patent application, it's now published, and your competitors can see where you are in terms of developing your ideas, and they may have a clever improvement that goes beyond that in a space that they may not have been able to grab onto as well. So there are some concerns and downsides to doing that as well.
I mean, startups are always encouraged to push things out quickly, right? So they can validate, iterate, but that kind of goes against the process of taking time, identifying and submitting a patent first. So what's your opinion on balancing these two things?
I think that the patent process doesn't have to slow down that, the iterative process that the startup's going through. As we talked about, filing a provisional application can be almost anything in terms of being very informal. And so it doesn't have to distract the team in terms of, spending weeks preparing a formal patent application. And so they have a documentation on the idea they're doing, or get somebody else outside patent counsel to have a short call with the person working on the idea. They can continue doing their good work while the patent process is operating in parallel. And often you don't need too much involvement from the people involved once the patent application gets filed.
The other option is, because the provisional filings are quite reasonably priced, you can file more than one provisional. And so often you may, like I've advised clients to file the initial provisional, and then as you continue your experiments or as you continue your work, if you reach a point where you get more and better results and it can kind of broaden things out or further, it just adds subject matter, that you then file a second provisional and then file a third provisional. And then within a year after the initial filing, you can file a formal patent application and claim priority rights to each of those provisionals. And so we often find ourselves litigating patents, for example, that claim rights to 2 or 3 provisionals. And each provisional filing just sets a different goalpost as to what was disclosed or what was filed, what was in there at that time. And that sets the priority rights at a particular date for that subject matter.
I mean, as a startup, am I supposed to be actively searching for existing patents before I start to build my product?
That's a bit of a complex question. In all likelihood, if you're doing a startup, you're probably, one would hope you probably have some awareness of that it's an area where patents are common, or at least someone may have patents in the area. And so having some knowledge of that, I see it as beneficial because you can see where others are innovating and see what has been protected and what may be available for protection. And what some kind of innovators find is that if they're aware of what patents are out there, they see that they are like head and shoulders above the others with what they're doing. They're so far advanced. And then it's like a no-brainer that you ought to seek patent protection. It's not without some risks, though. And Alan, maybe you want to talk about some of the risks?
Sure. And I think this is neither Geoff or I are U.S. patent lawyers, but the United States has some provisions on willful infringement of patents. And so if you are aware of a patent and proceed to infringe it, again, talk to a U.S. patent lawyer about the intricacies of that, but it can raise additional risk for a company that's in that situation. And so simply looking at patents for the sake of looking at patents sort of mixed on that, but I think it's in particularly something to keep in mind if the main thrust of your business is closely related to a competitor. You're taking their offering and taking to the next step. Those sorts of scenarios, it's often worth consulting a patent lawyer or taking a quick look at what patents they have out there in case you're walking into a trap. You don't want to spend years or lots of money developing a product just to find out that it directly infringes someone's patent and you're full stop.
Yeah, and so we do get involved when you have a company and they're innovating on new products and they've come across this patent of a competitor. They'll reach out to us and say, is this going to be a problem for us? And sometimes the answer is yes, very much it is. This is going to be a big problem for you. And then what we can do is we can help them design around it because we can give them some legal advice on what the scope of that patent is. And then they might have some ideas to design around it, and we can even suggest some ways to get around it. And then they can take their innovation in a different direction and respect the patent rights of others, but also make sure they avoid exposing themselves to patent risks.
I mean, say there's a patent out there, you're unknowingly using this in your product or in your business. I'm guessing you don't necessarily hear about this immediately, right? Like maybe sometimes people don't know, or maybe they're just not contacting you. I mean, when does that become a problem? I mean, are there situations where the patent holder never gets in touch with you?
Absolutely. And I think that's a good question, that often patents are not necessarily client-facing or external-facing, and so the patent owner may not exactly know who's infringing their patent. They may not be monitoring it, and if you don't know either, and I'd say in most cases, the alleged infringer is not doing this knowingly, that they've independently developed this technology and unbeknownst to them have fallen within the scope of someone's patent. And if the patentee never notices, then there's no issue. Neither side knows, and off you go. It obviously does become an issue if the patentee at some point looks around the market and realizes that somebody is infringing their patent, and then negotiation takes place, and whether that results in litigation or some sort of license agreement, or the alleged infringer decides to change their product, as Geoff said, do some sort of workaround, or change the direction of their business to avoid that patent. Those sorts of solutions take place all the time.
Yeah, I mean, what does happen when someone comes to you and says, hey, I've gotten a patent for this and you're using it? What happens next? How ugly and or expensive is that process?
It really does depend, and it really depends on, are they actually infringing? And, we spend lots of time looking at a patent in lots of detail to say, okay, what exactly is the scope of this patent? Is my client really doing what exactly it said there? And, patent lawyers start looking at every word, every comma of that patent to say, is this exactly what I'm doing, or am I doing something slightly different?
Yeah, and so what would typically happen is maybe a cease and desist letter would come, or some type of making the alleged infringer aware of the patent rights. And then we would sit down and with our client and look at the patent rights and decide whether or not there's an issue, or whether or not there is or is not infringement. And whether there is or not infringement may dictate what the response will be. And sometimes we've immediately stopped doing that, and the patentee might just accept that, or they might seek a remedy for the duration within which you were infringing. If it's closer to the line, or there's a view that there is no infringement, then that's obviously the response that would go back. And then the patentee may or may not accept that. They may decide to sue. They may ask for evidence of non-infringement, and you can have kind of without prejudice discussions to try and convince them as to why there is no infringement. But it does vary, and the level of trust between the parties does come into play. And If you have a field where it's highly competitive or the parties are very well aware of each other and don't like each other at all, those are the ones that tend to escalate quicker than others because of the level of distrust. But it gets interesting then.
And then once you get to litigation, sort of all bets are off in terms of how complex that is. And it really depends on what jurisdiction the dispute is. Is it only in one country, or you have to do litigation in multiple jurisdictions? My practice, for a variety of reasons, has often involved cases where there is parallel litigation going on. Canada, US, maybe Australia, litigation going on in China between the parties on different patents or different types of IP rights. And each country has its costs or quirks and defenses that can be raised, and that's where litigation comes in. And sometimes those go to trial, and sometimes those kind of proceedings settle at some point during the dispute.
And to flip the scenario around, if you're the one that's holding the patent and you decide, okay, I'm gonna assert this. As a startup, what should you be prepared for in terms of cost and time? Like, can a startup even afford it, right? Because one of the things I hear a lot is a patent is only as good as your ability and willingness to defend it. What are your thoughts on that?
Unfortunately, litigation is expensive, and it can be quite distracting as well from the operation of the company. There are lots of different ways that companies have approached that, especially in the United States. The litigation market's quite sophisticated in terms of litigation funding companies that basically invest in lawsuits in order to allow plaintiffs to bring meritorious cases forward so that they don't have to worry about the money side of it and funding litigation. And the other big aspect is licensing as well. If this is valuable technology, perhaps licensing the technology by way of a license on the patent to a larger player or a player in a different jurisdiction that you have no way of tapping into because of the scale of your company. Maybe they're the ones with the deeper pockets to actually enforce that if need be.
Yeah, so that's a conversation we have with our clients when they become aware of a potential infringer is, how far are you willing to go? Like, are you willing to sue? Because if they're willing to start a lawsuit and they're willing to see that lawsuit through, or even see it partially through, that will inform the strategy that we recommend. And so sometimes it might just be let's send a letter making them aware of your patent rights, and maybe we can talk about licensing, or it may be a full stop what you're doing or else, and then the next letter attaches a statement of claim. And so the level of aggressiveness will really depend on what the client's overall objectives are and what their appetite for litigation is and how much money they have available to put towards the problem. And as Alan mentioned, if it's a big market, then the client is much more likely to have not only the financial backing, but also the appetite to go after the infringer.
And what are patent trolls, right? That's a very, very popular word, I guess, in the startup community. And my question is, do they always win? Because, the law is the law, or are there ways to fight them because they've kind of made that their sole purpose?
Patent trolls, variety of definitions. I don't think I've come across a troll that likes being called a patent troll, so they try to use other terminology for that. But sort of the broad strokes, that's an entity that typically only has patents as its assets, and its business model is asserting those patents typically to obtain license fees. They're trying to make money, and the way they do that is license this technology to others. If people don't want to license that technology, then they sue until the person or the entity folds, and they either get a judgment from the court or they settle it and get some license fees that way. So that's their business model effectively. Some companies are sort of more aggressive and others are less so. But what's sort of interesting is that there are two sides of that issue about what are the merits of patent trolls, and quite a few of companies that may be called patent trolls are in some ways failed startups that a company may have come up with some clever ideas, filed some patents, and then for a variety of reasons, the business didn't work out, but they still have these patents. And so either the company remains simply with the patents and they're out there asserting those patents, or shift in business model, or someone buys the patents and says, hey, we don't really care about your business model, but we like your patents and we want to take them off your hands for compensation or an ongoing percentage of what we can recover or something like that. And that sort of addresses perhaps your earlier question of what do you do if you have a clever idea and patents but don't have the financial backing to actually assert them. There's companies out there who say we want to invest in that. That's our business model, is rewarding inventors who come up with clever ideas and enforcing those patents through licensing or litigation. But in terms of your other question, which is, do they always win? I think the answer is no. Some do, some don't. It really depends on the merits of the patents that are actually being asserted, and all the same issues arise. The patents may be found invalid, workarounds exist. The defendant is not actually practicing the specific scope of the claims that are being asserted. So yes and no. Because they don't have an otherwise operating business, there are certain tactics that can work in litigation and other kinds of litigation that don't apply to patent troll litigation, including that they have different incentives. Often if there's sort of two competitors that are operating a space, cross-licensing is often something that gets put on the table. Both sides have some patents. Let's sort of cross-license them and avoid this dispute. We both have something to lose here if this gets into a full-fledged litigation battle, whereas a patent troll that only has patents will be much less likely won't be interested in that because they don't have anything, they have no downside on that.
And what's the process for filing a patent? Can you talk through from day one, how long it takes, what it costs, what are all the different steps that are involved?
Sure. I don't think we need to get into all the steps on this, but I sort of at broad strokes, there's sort of, I guess, two parts to the patent filing process. One is drafting the patent application, and that involves working with the inventor or the team that's come up with the idea to describe the innovation, put it into words, put some figures to it as well, and to fully describe how to put that idea into best practice, into practice. That patent application can typically be filed as is in more than one jurisdiction. So once you have this patent application drafted, decision has to get made about where you're going to file it. It's going to be filed in Canada, the United States. There's also something called a PCT or International Patent Application, which sort of keeps the doors open to filing in almost any country of the world at a later date. And then once you file that patent application, you can't really change it substantively after it's been filed. So there's a real incentive to put everything that's relating to that idea into that patent application, because you can't say, oops, I forgot something once it's been filed, typically. So the first part, drafting the patent application, I usually say about 6 weeks or so. It can be done much faster if there's a pressing deadline or some sort of other reason to do so. Sometimes it takes longer if the team is busy meeting other deadlines, because sometimes there's involvement of the inventor sort of looking at drafts and approving that patent application process. And then once it's filed, it really depends on each country. And as we sort of talked about, sort of the 2 to 5 year time frame for that patent application to go through the patent office and deal with any objections the patent office has raised, and you get a granted patent.
And for anyone listening right now who's thinking to themselves, I need to get this process started, how do they get in touch with you guys?
Both of us are listed on the DLA Piper website, and we'd be happy to chat by phone or email and take it from there. And we're obviously based in Toronto, but it's a global world, and we can connect with people from anywhere. And we have many colleagues in other jurisdictions as well that may be closer to home, and be happy to work with you as well.
Awesome. One last question. What are some final words of wisdom that you want to leave with our listeners today, who are bootstrap founders who are focusing on driving growth and profitability?
So for my, the final words of wisdom, maybe if we can call them that, I certainly have the view that if you're in an industry where there is innovation and it's a kind of, even if it's an area that's kind of on the forefront of developments and things of that nature, if you step back and look at the industry and look at the direction it's going, try and take a look at some of the key points where you can maybe seek out innovation and develop in that area, and then seek patent protection, and that may give you a leg up on your competitors. And it's really, in my view, it's never too early to start thinking about that type of thing. Just like, you should think about seeking trademark protection and things of that nature. But certainly when it comes to, you want to have a successful business in an area where there's technology and technological innovation, you want to have an effective means of capturing the innovation that you're doing and seeking patent protection early enough so that you can not only make sure you do capture it for the future so others don't and prevent you from developing the area, but also you start to develop these wonderful assets, and your patents you can develop quite a broad patent portfolio if you do it properly and effectively. And then it's a wonderful asset. It's value to the company. moving forward. And you have those patents for 20 years. And so for 20 years, you can have a leg up on your competitors if you do it well and you do it strategically. What's sad, what's disappointing is when a startup comes to you too late and they've already disclosed or they've already, innovation has passed them by. Whereas getting ahead of it truly can be a real value to the company and help you to succeed in the competitive space.
I guess I would have a similar theme, but perhaps a slightly different angle on it, which is looking long-term in terms of patents. Patent strategy in terms of filing or trying to obtain patents is not something that gets done in months. It's a longer-term project, and you got to companies should look, where do we want to be in 1 year? Where are we going to be in 5 years in terms of their patent strategy? And unfortunately, too often I've seen companies come to me all keen about filing patent applications. We file a bunch of patent applications, and then within a year or two, the company has changed direction and they've come to us and say, we want to abandon those. We don't want to pursue them any further. And that's a loss on that time and energy that the company spent at that time preparing patent applications. So we're going to invest it, know why, and know where you want to be in the longer term.
Well, thanks, guys. If you enjoyed this episode, don't forget to subscribe to ProfitLed and be notified of new episodes. Head over to our website, profitled.fm, to see the show notes of this episode and how to get in touch with Alan and Geoff. Alan and Geoff, this was awesome. Thanks so much for taking the time to join me today and sharing all this valuable information.
Thanks for listening to ProfitLed. If you enjoyed this episode, we hope you will subscribe to the ProfitLed podcast and head over to our website, profitled.fm, to see the show notes of every episode. You can also join our mailing list to be notified of new episodes or when we have interesting products and resources to share. We promise to only share things you'll actually care about. Thanks again for listening. Bye now.